It is indeed an honour to open this important debate this afternoon and to serve under your chairmanship, Mr Holloway. And as I begin, I'd like to draw members' attention to my entry in the Register of Members' Interests. And it would be remiss of me to start my speech without paying tribute to my honourable friend, the late Paul Goggins, who was such an assiduous advocate for mesothelioma sufferers and for their families. I attended his funeral the week before last at Salford Cathedral with many other colleagues, and in conversation with the honourable member for Foyle, reflecting upon Paul's innate decency and his many wonderful qualities, he summed up Paul's parliamentary contributions, saying that his arguments were well marshalled and his responses well-mannered. In making my contribution today, I will strive for those high standards, but I fear I'll never be able to emulate such a brilliant parliamentarian. In essence, Mr Holloway, I believe that this is a mercifully simple matter, but it perhaps warrants a few moments in establishing the background. We're here to address specific provisions within the Legal Aid, Sentencing and Punishment of Offenders Act 2012, which I'll hereinafter refer to as LASPO, that particularly relate to mesothelioma cases. The relevant background is, of course, that changes were made by LASPO to the way in which the generality of legal cases were funded. And I practised for many years as a solicitor with Thompson's, and before arriving here in this place in December 2012, headed up a specialist unit looking after those who suffered catastrophic injuries, including brain and spinal cord injuries, and sadly, on too many occasions, cases resulting in fatalities. I also had the privilege of representing members of the armed forces who sustained serious injuries in the service of their country. But I never did represent those suffering from asbestosis or mesothelioma, but I did have the privilege of working alongside some wonderful colleagues who devoted their professional and often significant parts of their personal lives to the service and representation of those suffering from this most dreadful of diseases and, of course, their families. And I paid tribute to the tireless work of my former colleague Ian McFall, who is not only an international authority in the field of mesothelioma litigation, but has been and continues to be a wholly committed advocate to the cause. Mr Holloway, with the move away from legal aid support for personal injury cases, and with such state support being removed altogether, the era of the conditional fee agreement came into being. And I cannot count the number of conversations I had whilst in practice over many years trying to explain that the description of the so-called no-win, no-fee agreements was wholly inadequate. The basis of such conditional fee agreements, as they are properly termed, was that in the event of a claimant being unsuccessful, he or she would not face a bill for either their own costs and disbursements or those of their opponent. Any risk was principally borne by the claimant's lawyers. Their reward was when they succeeded for their clients. They benefited from an uplift on their costs, a success fee that was paid for by the unsuccessful defendant. All of that was designed to take account of the other cases which were unsuccessful. The structure was underpinned by insurance, so that in the event of the claimant not succeeding in whole or in part, that insurance would provide cover for the unrecoverable disbursements and the defendant's costs. In the absence of suitable pre-existing, before the event, legal expenses cover, that policy would be arranged on an after-the-event basis known as ATE. The premium in relation to that insurance was borne by the unsuccessful defendants in cases where the claimant won. So in successful cases, the defendant bore a success fee and the ATE premium. All of that changed with LASPO. In short, as from the 1st of April 2013, in return for a 10% uplift on the damages paid, the principle of recovering success fees and ATE premiums was extinguished, and those items of cost would now fall to be paid by the claimant representing a significant erosion of a claimant's damages. The argument was had in this place that mesothelioma cases should not fall foul of these provisions, and those cases should be exempt. The exemptions, as recited in Section 44 concerning success fees and Section 46 relating to after-the-event insurance premiums, were entirely the right things to do. And the reason it was the right thing to do was eloquently summed up by Paul Goggins in recent times when he said an amendment was passed in the House of Lords that exempted mesothelioma sufferers. Honourable members from both sides will recall our vigorous debates in the House of Commons over the issue and the strong sense that it was repulsive that people who are given a diagnosis of mesothelioma and know that they might have only months to live might have to give up 25% of their damages to pay a success fee to their lawyers, and would therefore have to shop around to get the best deal from those who might represent them. The idea was repulsive. Mr. Hollowborn, the idea remains repulsive, and no case has been made to change the position. A claimant in such dire circumstances should be focusing upon the quality of representation and nothing else. The exemption, securing 100% recovery, allows that to happen. Section 48, Mr. Hollowborn, makes it clear that there would be a review in that sections 44 and 46 could not be brought into effect in cases of diffuse mesothelioma until such times as the Lord Chancellor has carried out a review of the likely effect of those sections in relation to such proceedings, and secondly, that the Lord Chancellor publishes a report of the conclusions of the review. And the Government will doubtless point to the consultation launched in July 2013 on mesothelioma claims, and the particular section that concerns us is contained within Chapter 4, which runs to 3 pages and asks the question, do you agree that sections 44 and 46 of the LASPO Act should be brought into force in relation to mesothelioma claims in the light of the proposed reforms described in this consultation, the increase in general damages and costs protection described above, and the mesothelioma bill? Well, with respect, Mr. Hollowborn, that can hardly be properly described as a review, but more importantly, that chapter was dealing with one of many matters consulted on, to include fixed costs, secure gateways, new protocols, all of which were abandoned. It simply cannot be properly described as a review, but equally, what has happened subsequently is not by any means a report. Mr. Hollowborn, what we have had is an announcement which was made on the 4th of December 2013 by way of the written ministerial statement of the Parliamentary Under-Secretary of State for Justice, the Right Honourable Member for North West Cambridge, who announced that the Government, and I quote, has concluded that it intends to apply sections 44 and 46 of the LASPO Act to mesothelioma cases. That is not, by any stretch of the imagination, what could amount to a credible review or a report as is specified by Section 48. Statute says that those things simply have to happen before the relevant sections can apply to mesothelioma cases. To have introduced a new regime in April 2013 with these exceptions, and then to consult on whether those exceptions should still apply alongside a whole host of other matters in relation to mesothelioma claims in July 2013 is simply ludicrous. It is simply far too soon. just some 3 months between the introduction of the new regime in April 2013 and then the July review in 2013 for any proper assessment of the likely effects of sections 44 and 46 upon mesothelioma claims to take place. Nobody can tell at this stage how much clients are going to be charged by solicitors under LASPO. It's a developing situation as the market adapts. And the same can be said with regard to the cost of ATE insurance. Government is jumping the gun, and it needs to pause and commit to a genuine process of review.
On that point.
Yeah, for his intervention, it's very apposite. The only way I would slightly disagree with him when he says it's poppycock, perhaps not in the legal sense. I think we may find that there are some legal consequences to this, because I'm of the view that it doesn't withstand scrutiny as a proper process. So we no doubt will return to that. But to make these changes at this pace makes it abundantly clear that the government had made its mind up way before April 2013 that these exemptions wouldn't last any time at all. And thereafter, by trying in some tortured way to create a link between the mesothelioma scheme, as laid out in the Mesothelioma Bill, and the provisions in LASPO, is to simply conflate unconnected matters. I've got to say, Mr. Hollowbone, that if there was one American blues artist who would epitomise the approach of the government on this issue, it would have to be the inimitable Muddy Waters himself. I'll happily give way. She makes an absolutely valid point. I haven't seen no evidence of that being so, and I think what we're doing here is trying to compare apples and pears, and it simply it doesn't work. Indeed, there shouldn't be any linkage between LASPO and the Mesothelioma Bill. We're dealing with wholly separate and distinct matters. On the one hand, we're talking about the conduct of cases where employers and insurers are known and the cases progress in the ordinary way. On the other, we're effectively talking about a scheme to deal with cases where insurers are not traced. It's simply disingenuous and grossly insulting to sufferers to somehow try and make a link between the two and to somehow justify the changes that will impact upon the conduct of civil cases by virtue of an untraced scheme being progressed. If someone suffering from mesothelioma can trace an insurer, their case will proceed in the ordinary way. The others who cannot locate an insurer have reference to a scheme that has no bearing whatsoever on the conduct of ordinary civil cases, and it would be refreshing if the Minister could make that abundantly clear when he comes to respond. As in my view, there's no integrity whatsoever in such an argument. Without success fees, some cases which should be run will not be run as being too risky, without a success fee to justify and enable the risk to be taken. Removal of the exception will result in either such cases not being run or mesothelioma victims having to pay out of their compensation. This was clearly not the intention of Parliament, and I would urge the Government to reconsider.
Begin by congratulating the Honourable Gentleman for Middlesbrough for bringing forward this debate, and like him, I'd like to start by paying tribute to the work of the late Paul Goggins, who was a fantastic campaigner on the issue of the mesothelioma, and I too went to the funeral at Salford Cathedral a couple of weeks ago, and it was an incredibly emotional and yet wonderful occasion where people were paying tribute to his life. And what many things touched me throughout that service, but one thing that happened which really made me realise the man that he was when Tony Whitson, who has been a long-time campaigner for asbestos victims, came up to me afterwards. And it just made me realise that he'd reached out beyond Parliament and beyond his own community to a much wider community. And he was very well known for fighting many causes. But this is one he and I shared a great passion on. It still feels very bizarre that we're having a debate in this House on mesothelioma and he is not here. And I still keep looking out for him in Portcullis House, as I'm sure many colleagues do, wondering what he is going to say and what he's going to contribute to issues like this.